Hello and welcome. Today we're diving into a crucial area of law, wills and succession. Specifically, we'll be focusing on the role of witnesses in a will and two important concepts, codicils and incorporation by reference. By the end of this session, you will be able to identify who can and cannot be a witness to a will, understand the effect of a witness being a beneficiary, define a codicil and its requirements, and explain the rules for incorporating other documents into a will by reference. These topics are not just academic, they are frequently tested in the bar exam, so let's break them down step by step. Let's begin with the core requirements for a witness. Article 820 of the Civil Code lays out the general rule. It states that any person of sound mind, at least 18 years old, not blind, deaf, or dumb, and able to read and write, can be a witness to a will. Let's break that down. First, sound mind means they must understand the act of witnessing a will. Second, they must be an adult, at least 18 years old. Third, they must not have a sensory disability that would prevent them from perceiving the execution of the will. And fourth, they must be literate. To help you remember these, let's use an acrostic. Think of A, W-I-L-L, as needing A, S-A-F-E, witness. S stands for sound mind. A for age of 18. F for free from sensory defects like blindness, deafness, or muteness. And E for educated, meaning they can read and write. So a safe witness is a competent witness. This is the foundation. Now let's look at the flip side. Who is disqualified from being a witness? Article 821 lists two categories. First, any person not domiciled in the Philippines. Second, those convicted of falsification of a document, perjury, or false testimony. The first disqualification is about residence. A person must be domiciled in the Philippines to be a witness. This is to ensure they are subject to the jurisdiction of our courts if their testimony is needed. The second disqualification is about character. A conviction for crimes involving dishonesty, like falsification or perjury, makes a person untrustworthy as a witness. This is a permanent disqualification. Let's consider a scenario. Suppose a testator, Mr. Reyes, asks his friend, Mr. Smith, to be a witness. Mr. Smith is a U.S. citizen who has been living in the Philippines for 10 years on a tourist visa. Is he a competent witness? The answer is no. While he meets the SAFE criteria, he is not domiciled in the Philippines. Domicile requires intent to reside permanently, which a tourist visa does not imply. This is a common issue. The remedy is simple. Choose a witness who is a Filipino citizen or a foreigner who has established domicile here. Always verify the domicile of your witnesses. What happens if a witness is competent when the will is signed, but becomes incompetent later? Article 822 addresses this. It states that if the witnesses were competent at the time they attested the will, their subsequent incompetence does not prevent the will from being allowed. This is a very important principle. The law looks at the moment the will is executed. If the witnesses were qualified then, the will is valid. Their later circumstances, like becoming blind or moving out of the country, don't retroactively invalidate the will. Let's imagine a scenario. A will is executed in 2010 with 3 competent witnesses. In 2020, one of the witnesses is convicted of perjury. Does this invalidate the will? No, it does not. The witness was competent in 2010 when the will was signed. Their conviction in 2020 is irrelevant to the will's validity. The will remains valid. The key takeaway is that competence is determined at the time of attestation. This prevents wills from being challenged years later due to unforeseen events in a witness's life. Now for a critical and often confusing topic. What happens if a witness is also a beneficiary? This is covered by Article 823. The rule is that if a witness, or their spouse, parent, or child, is given a devise or legacy in the will, that specific gift is void. However, the witness is still admitted as a witness, and the rest of the will remains valid. Let's repeat that. The gift is void, but the witness is still a valid witness. This is a compromise. The law wants to prevent fraud or undue influence, so it takes away the witness's incentive. But it doesn't want to invalidate the entire will just because of one problematic gift. There's a crucial exception. The gift is not void if there are 3 other competent witnesses to the will, besides the beneficiary witness. So if a will has 4 witnesses, and one of them is a beneficiary, the gift to that beneficiary is still valid. The 3 other witnesses provide sufficient independent attestation. Let's use an acrostic to remember this. Think of A. BAR, TIP. BAR stands for Beneficiary Attesting Renders Gift Void. B for beneficiary, A for attesting, R for renders gift void. This is the general rule. Remember the exception. If you have 3 other competent witnesses, the gift is saved. Let's solidify our understanding of Article 823 with a bar exam style question. Question. Testator T executed a will with 4 witnesses, A, B, C, and D. The will gave a legacy of P100,000 to witness A. Is the legacy to A valid? Take a moment to think about it. Remember the rule and its exception. The answer is yes, the legacy is valid. According to Article 823, a legacy to a witness is void unless there are 3 other competent witnesses. In this case, there are 3 other witnesses, B, C, and D. Therefore, the legacy to A is saved. This is a classic trap. Many students would immediately say the gift is void. But the key is to count the total number of witnesses. If it's 4 or more, and 1 is a beneficiary, the gift is valid. Let's look at another specific case, creditors as witnesses. Article 824 clarifies this. It states that a mere charge on the estate for the payment of debts does not prevent a testator's creditors from being competent witnesses. This means that if you owe someone money, you can still ask them to be a witness to your will. The fact that they will be paid from your estate does not make them an incompetent witness. Why is this? Because the payment of debts is a legal obligation, not a gift or legacy. The creditor is not receiving a benefit from the will itself, but merely getting what they are already owed. Therefore, there is no incentive for them to commit fraud. So, if Mr. Cruz owes his friend Mr. Lim P 50,000, Mr. Cruz can still ask Mr. Lim to be a witness to his will. Mr. Lim is a competent witness. Now, let's shift gears to our second major topic, codicils and incorporation by reference. We'll start with codicils. Article 825 defines a codicil as a supplement or addition to a will made after the original will was executed. Its purpose is to explain, add to, or alter dispositions in the original will. Think of it as an amendment to a will. If you've already made a will but want to make a small change, like adding a new beneficiary or changing a specific gift, you don't have to write a whole new will. You can create a codicil. The most important rule about codicils is found in Article 826. It states that for a codicil to be effective, it must be executed with the same formalities as a will. This is a critical point. A codicil is not just a simple note. It must be in writing, signed by the testator, and attested by 3 competent witnesses in the presence of each other and the testator. It must also be acknowledged before a notary public. In other words, it's a mini-will. A common problem is people writing informal notes to change their will. For example, a testator might write a letter to their lawyer saying, "Please give my car to my nephew." This letter is not a valid codicil because it lacks the required formalities. The original will, giving the car to someone else, would stand. Finally, let's discuss incorporation by reference, as outlined in Article 827. This allows a will to refer to an external document and make it a part of the will, even if that document wasn't executed with the same formalities as the will. For example, a will might say, "I give the items listed in the inventory attached to this will to my children." The inventory itself doesn't need to be signed by witnesses, but it becomes part of the will by reference. However, there are 4 strict requirements for this to be valid. Let's use the acrostic EDIS to remember them. E stands for existence. The document must be in existence at the time the will is executed. D for description. The will must clearly describe and identify the document. I for identification. The document must be proven to be the one referred to. And S for signature. The testator and witnesses must sign every page of the document, unless it's a voluminous book of account. A common problem is failing the existence requirement. A will cannot incorporate a document that is to be created in the future. For example, a will cannot say, "I give the items I will list in a notebook next year to my sister." The notebook must exist when the will is signed. Let's test your understanding of incorporation by reference with a bar exam question. Question. Testator T executed a will stating, I give the items listed in the inventory I will prepare next month to my son, S. T died, before preparing the inventory. Is the gift to S valid? Think about the EDIS requirements, especially the first one. The answer is no. The gift is not valid. The inventory did not exist at the time the will was executed. This violates the first requirement of Article 827. The gift fails. This highlights the importance of the existence rule. The document must be a pre-existing one. Let's recap what we've learned today. We covered the essential rules for witnesses to wills. We learned that a competent witness is safe, sound mind, age 18, free from sensory defects, and educated. We also saw that a witness must be domiciled in the Philippines and not have a conviction for falsification or perjury. We also discussed the effect of a beneficiary witness, remembering the BAR tip and its crucial exception. We clarified that creditors are competent witnesses. Finally, we explored codicils, which are amendments to wills that must be executed with the same formalities as a will. And we learned about incorporation by reference, which allows external documents to be part of a will, provided they meet the EDIS requirements: existence, description, identification, and signature. For your bar exam preparation, here are some tips. First, memorize the articles and their key terms. Second, practice applying the rules to different scenarios, especially those involving exceptions. Third, pay close attention to dates and the number of witnesses in a problem. These details are often the key to the correct answer. By mastering these concepts, you'll be well prepared for questions on witnesses, codicils, and incorporation by reference. Thank you for watching.